Lawyers of Reddit. What are some myths people actually believe about the law that drive you crazy? The biggest one that comes to mind is the infamous McDonald's case. You've probably heard of it. A cranky customer spilled a bit of coffee while driving and decided to sue McDonald's for millions of dollars because it was too hot. How ridiculous. Coffee is supposed to be hot, right? In reality, the coffee was almost 200 degrees Fahrenheit, considerably hotter than what anyone would expect, and had caused several injuries before this incident. The elderly woman was actually parked and not driving at the time. She spilled the coffee on her lap and it caused third-degree burns on her genitalia, thighs, and buttocks. She needed skin grafts and had to be hospitalized for more than a week. Initially, she only asked McDonald's to cover her hospital bills, and McDonald's replied with an insultingly low offer that only covered about 10% of the bill. A jury heard all of the facts, decided that the woman was actually 20% at fault for spilling the cup, and still found McDonald's 80% responsible for the incident. The case is sometimes called the poster child for frivolous claims. In reality, it is a prime example of anti-legal spin designed to discredit legitimate lawsuits. A documentary was created about the case, which argues that the widespread misconceptions were purposefully spread by McDonald's and other groups after the case to discourage litigation and encourage tort reform to prevent such frivolous cases. It really is an unfortunate misconception that needs to be cleared up. The Wikipedia article can tell you more if you are curious. Edit. Thanks to whoever gilded me, it's my first. Some people have insisted that coffee should be brewed at 200 and asked me to explain that with outcome of the case. This was news to me, and Google quickly confirmed that. A lot of people feel 200 is the proper temperature at which to make coffee. There are a couple of things that may explain this. First, it's entirely possible that I've been wrong all this time, and perhaps Mickey D's was unjustly taken to the cleaners. What I think is more likely is that the internet is inaccurate for whatever reason. I do not brew my coffee at those temperatures. Brewing so close to boiling will make the coffee more bitter and ruin the flavor. The colder you brew your coffee, the better it will taste. Brew it with cold water in the fridge overnight if you have the time. A lot of restaurants may brew it at 200 because speed and keeping the coffee hot are more important than the taste. I believe McDonald's advocated that temperature during the lawsuit because restaurant practice was to make the coffee overly hot so it was still hot when the drive-through customer arrived at their destination. Further, I would hazard that these temperatures are now industry standard in part because of the smear campaign I mentioned. The Wikipedia article lists that several subsequent lawsuits against companies were unsuccessful because opinion shifted and the populace believed that the coffee was at the appropriate temperature. Think about that. McDonald's admitted that it kept the coffee hotter than normal to keep it hot longer, and 2 decades later that is so standardized that everyone thinks their coffee should be made at that temperature even though it ruins the flavor. The smear campaign was incredibly effective. At any rate, even if coffee is brewed at those temperatures and kept that hot for convenience, 200 is still much too hot to drink and dangerous to handle. Part of the jury's consideration included the inadequate warning on the side of the cup that the coffee was too hot to drink and the drinker should exercise caution. Edit 2. Some kind persons have also pointed out that regardless of how you brew or store coffee, serving it at 180 to 200 degrees is dangerous. It is undrinkable at that temperature and will cause burns. Someone also pointed out that during the trial, the MCD's spokesman was asked what would happen if someone drank a mouthful of 200-degree coffee, and they admitted it would cause injury. I'm not sure if this actually happened, but it would make sense. Edit 3. I've been trying to respond to all the comments and questions to foster discourse on the subject, but many of you are commenting on how you prefer your coffee hot, so the woman must be 100% at fault. Some of you are trolling while some of are either ignoring the facts or have lost contact with reality. Look at this picture of the woman's injuries. Tell me you drink coffee that hot and I call you a liar. Yes, the woman was partially at fault for negligently spilling the coffee cup, but in most jurisdictions partial negligence does not prevent recovery. Had the coffee been at a safe temperature or had the woman been adequately warned, then she would have a larger share of the blame and may not have recovered, or, more likely, the accident would have been avoided entirely. Instead, MCDs knew that their coffee was dangerous, continued serving it so hot that it caused third-degree burns, and did not warn the woman how hot the coffee was. Some of you are providing websites that say coffee should be served at 180, but are ignoring that 180 is still undrinkable and at any rate cooler than the coffee that burned the woman. MCDs served this coffee not at a stable table but to an older woman in a car. You're also ignoring that these websites exist after a 2-decade campaign to discredit the woman and reaffirm MCD's position that coffee should be served scalding hot. Some of you might be able to handle 180-degree coffee, but more than likely you are mistaken, and none of you drinks 200-degree coffee. I don't care how internet tough you think you are. I welcome any questions and comments, but I'm not going to address any other rude comments about how stupid and clumsy the woman was or how tough you are. Those are my thoughts. Anyway, but again, it's possible I am mistaken. If someone has debt and dies, their family does not have to pay it off. But some banks will try to get them to anyway in case they think they need to. As Reddit has helped show lately, when a debt is owed in the United States, the debtor can pay the debtee with any valid currency, and the debtee must accept it. However, this only applies when a debt is owed. The guy at McDonald's does not have to break your $100 bill for a $2 cheeseburger, and the guy at the liquor store doesn't have to take your Ziploc baggies full of pennies for your Four Loko. When a good or service is being sold, it's up to the discretion of the seller whether or not they accept any given currency. Contrary to popular belief, a husband and wife can be charged for the same crime. That you can weasel out of a contract or break the law by trying to be clever with language and finding loopholes. Courts will apply the test of reasonableness. Would a reasonable person interpret the contract regulation the way you are trying to? I am not a lawyer, but I am in the medical profession. Please note that I am generalizing. People erroneously think that every undesired medical outcome is a slam dunk lawsuit winner. That is not the case. In order to win a malpractice lawsuit, you typically have to prove either that the medical decisions, interventions, care were different than what a reasonable provider would have done in a similar situation, or you have to prove actual malice. Almost impossible to prove. You also have to prove that actual harm was done. If a child comes in with a 2-day history of a runny nose and fever, guess what? That child has a cold. Fever medication, fluids and rest are what the doctor is going to prescribe. If it turns out the child has some weird 1-inch, 100,000 cancer and dies from it, it is going to be almost impossible to win anything more than a go away and quit wasting our time settlement because any other reasonable provider would have arrived at the same diagnosis. TL. Doctor, life is not fair and it happens. Valor Morgulis, that the First Amendment applies to entities other than government. It does not. You don't have free speech rights on Facebook or in a football stadium. This is kind of a specific one, but being the victim of a crime doesn't exempt you from punishment for subsequent crimes. I had to defend an admitted child molester, and I must have spent a good month explaining to him on multiple occasions why I was molested in church as a kid, and that's why I touched those little boys was not a good defense strategy. Signs put up in stores or waiver signs stating that you agree not to hold a person or business responsible for harm done to you on their premises or by them are not legally binding. If you're driving behind a dump truck and it says not responsible for broken windshields from falling gravel, that's bullshit. They're responsible because they're hauling gravel on a public thoroughfare where other people are. They're responsible for all damage their vehicle and their load does. They just put those signs up to deter lawsuits. You can't waive liability for possible harms that might happen in the future. At least, you can in Missouri. I tried. So, stores that have signs that say not responsible for injury or accident done while on the premises is bullshit. Even if the document looks official and you signed it, you can't sign away your right to sue for future harms. Not a lawyer, but people seriously have no idea what entrapment is. Pro tip: if you're selling drugs to someone and you ask if they're a cop, it's not entrapment if they lie and say no. That a person can shoot a Welshman with a longbow after sundown if they're on the other side of the English-Welsh border. This possibly originated as a reasonable response when we were at war and a proactive militia was needed. Maybe the law was never technically repealed, but some pre-17th century law doesn't supersede the fact that it would still be murder wounding GBH. Also, I'll throw this out there. I don't know why why businesses put up signs that say we have the right to refuse service to anyone. I've had shop owners tell me that they were told that the rule only applies if they have the sign up. I think this is a ploy by the sign makers to keep themselves in business. Any business has the right to refuse anyone, and they don't have to give a reason. Just be careful if you do give a reason, as that can lead to trouble. My advice would be to simply tell the person, "I'm not comfortable serving you today. Please leave." If they argue with that, don't tell them anything else besides that you're calling the police and you'd like them to leave. Call the cops if they don't leave. Once you've clearly asked them to leave your business, if they don't immediately make an effort to evacuate, it's trespassing, which is enough to get a ticket, if not arrested. Most places, by owning land you are then free to do whatever you want on it. It seems people think because they own a 1/4 acre lot they can set up their own country and are free to beat, kidnap, or kill anyone who accidentally steps onto their borders. Not really a misconception about the law per se, but my head wants to explode with rage when I hear, "Oh, law school. I'd be great at law school and being a lawyer because I am so good at arguing with my mom." In reality, being a lawyer is more akin to a research librarian than it is arguing with people that they get paid to lie. Zealously representing your client's position and lying are not the same. Sure, some do, and some get away with it, and maybe clients would prefer it if that was what they were actually paying for. But there are professional duties to uphold and sanctions in light of their abuse. Basically, I'm tired of my relatives saying, "So you're one of those dirty crooks now," since I've graduated from law school and taken the bar.